You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. I'll share with you some of the messages that you have brought to us as far as the two matters we have discussed are concerned. Okay, so where do I begin? Kofi Bento says, it's about quality control from ground up, not at the law school level alone. So echoing the point that Inus Afuseni did mention. He says, Russia produces very few vehicles. Germany produces millions of cars. Germany, the mass producer, produces the best quality vehicles. What an example. And then one of the students who just passed, and he will be called to the bar, says that they just did not want to admit, and this is because in our year, we, those who got 50% and above, were few, and the pass mark came down to 45%. Thanks for your message. And a senior at the bar also says, I don't know why, you know, there's something about this thing and too many people will not want to be identified. So when you hear Inus Afuseni, you hear Kweku Asare and the rest, they are really bold and brave because too many don't want to be heard about it. When you hear Isankuma and the rest of them talking very boldly about it and publicly, it is because that is what they are made of. Now, this is asking the question that the Attorney General, do you know there are not more than 5? Okay, so he's asking again, do you know that legal aid has only 22 lawyers? Legal aid has only 22 lawyers. That is a sad situation that we must work to improve. Kwame Siedu-Sapon says, I am horrified at what the Deputy Attorney General is saying. Let me put some context on this. In this country, there are, is it 4,016 or so doctors with a doctor to population ratio of 1 doctor to 73,074. Is that what he says? Okay, I'm not too good with the figures. We all cry for doctors, so training has been expanded. Now Cape Coast, Tamale and Ho all train doctors, and now there is a private medical school. This situation pertains in most health-related fields. I understand there are just over 4,000 lawyers, meaning the lawyer to population ratio no different from that of doctors. It's about, you know, is it 8,000 or so per lawyer. Interestingly, the lawyers and judges are against expansion of legal training for more doctors. Has the increase in doctor numbers affected quality? To me, the jury is out. Cognitive dissonance, I call this. One of the students who also couldn't make it says that, she says, look, I studied for 3 years. I quit my job to fully concentrate on my studies because I know I had to dedicate my time to the path I had chosen. I performed very well with the LLB and I am examined on some few basic questions, only to be told I don't qualify to become a lawyer. CJ's talk about character, and I am only wondering, how have I been assessed on my character with the questions that I was asked during the entrance exam? Interesting there. Lawyer Opoku Ejei says that September 11 hijackers used box cutters, no guns, no explosives. Okay.
But that was treason. That was
thank you.
Terrorism. That was not subversion.
Right. Let me read this one. Nana Hesi Ojiri, he says that Kweku Bako just said that the CJ is too conservative. Why not? A profession that refers to 8 colleagues as learned friend. Why won't the profession be termed a conservative profession? Now, what led to the mass failure? What was it that the marking scheme was raised? Does it mean the lecturers are not well equipped or the students are the problem? Yes, the CJ is against mass production, but did the student pass and were intentionally failed? I'm only observing. Okay, Nana, thank you for your messages there. Now let's go to, I'll read your messages later on the coup matter. Let's start with Inusa Husseini. So, what is it that those of you who are against the white paper are talking about on the short commission? And last week I made a reference that the Constitution Review Commission, when it finished its work, the government accepted over 90%. And yet, some of us criticized the white paper so rambunctiously. Yes. I remember my article on it. I titled it Cabinet Coup d'etat. So what is it about this white paper that too many people are so unhappy with?
Thank you so very much, Samson. Indeed, we don't have time, so I'm not going to give the facts of the case of the by-election which led to the establishment of the commission, because the facts are well known. So the report was submitted on the 14th of March, and by the constitutional injunction, the president had within 6 months to issue a report, and a white paper. Now the government has subsequently issued a white paper, and the white paper, with the greatest respect, is an exercise in dishonesty. The white paper has sought to supplant the commission by giving its side of the story. And you can see it even from the first opening paragraph of the white paper. Nowhere in the Commission of Inquiry report did they establish that the violence that took place at Ayos West Wagon constituency was as a result of a press conference given by the chairman of the NDC and confirmed by Honorable Sam George. Nowhere. But look at the white paper. The opening paragraph. In the morning of 31st January 2019, barely a few hours after voting had commenced in the Ayawaso West Wogan constituency by-election, following the death of Honorable Member of Parliament, Mr. Emmanuel Chermetena Jako, the national chairman of the opposition NDC, Mr. Samuel Ufosu Ampofu, addressed a press conference where he alleged that the NDC parliamentary candidate and 6 party agents and accredited observers had been shot by the invisible forces who have been given national security uniform, resulting in serious injuries. These men, according to the national chairman, and blah, 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 they say that these allegations, paragraph 2, these allegations which caused widespread national alarm and outrage led the president of the Republic, Nana Addo Dankwa Akufo-Addo, to appoint a commission of inquiry. That's the white paper that is saying so.
Yeah, the white paper, is that not the view of government on the matter? Are they saying?
Just hold on. Just hold on.
That's the white paper.
Yeah, are they saying that's what
the white paper is telling us?
Hold on, let him finish.
The white paper is telling us that it is because Samuel Ufosu Ampofu gave a press conference, which press conference led to violence.
No, I'm not sure.
But that's it. I'm reading from the white paper.
No, please, go.
I'm reading from the white paper. I'm not reading from anywhere. Paragraph 2. No, you see, and because of that, I have gone back to the Constitution. And what is the white paper? What is a white paper? According to Black Law Dictionary, a white paper is a policy document. For our purposes, the white paper which is by law under Article 2803, the president has to issue when publishing the report, is to give an indication of the standing of government in relation to the report. It is not intended. It is not intended to substitute for the report.
Yeah, I mean.
No. So, no, in fact, no matter what objections the government had to the findings of the committee of inquiry, those findings still stand by the Constitution. And Article 283 is clear. 283 is very clear on this matter. And so any adverse finding made against anybody, irrespective of the fact that the white people have said, no, we don't agree, does not operate to remedy or overturn the findings of adverse findings made against the person. That is the Constitution.
Okay.
And it's stated. So you go to 3. The president shall, subject to clause 4 of this article, cause to be published the report of a commission of inquiry together with a white paper on it within 6 months after the date of the submission of the report by the commission. 4. Where the report of a commission of inquiry is not published, the president shall issue a statement to that effect, giving reasons why the report is not to be published. Look at 5. A finding of a commission of inquiry shall not have effect of a judgment of the higher court, as provided under clause 2 of this article, unless 1. 6 months has passed after the finding is made and announced to the public, or B. the government issues a statement in the Gazette or in the national media that it does not intend to issue the white paper on the report of the commission, whichever is earlier. When does your right accrue to challenge the findings? Your right to accrue to challenge the findings, irrespective of A or B, is the right to appeal conferred on clause 2 of this article on a person against whom a finding has been made, shall be exercised within 3 months after the occurrence of either of the events described in clause 5. That is, the government has published the report in the white paper, or the government has refused to publish the white paper. That is when you're right. So it means that the findings in the report, irrespective of a publication of a white paper or not, stands. And your right to challenge the findings accrues 6 months, 3 months after the publication or otherwise. In this case, 3 months after the publication, your right to challenge the findings is established. So no matter what they have said here, to all intents and purposes, it gives us government stance on the commission of inquiry. But what is more worrying is government's attempt in its white paper to attack the integrity of the commissioners. Government is saying in this white paper that the commissioners failed to appreciate the import of the terms of reference that was given to them. It is because, in its view, that the commissioners failed to appreciate the import of the terms of reference and the remit of the terms of reference. That's why they failed to address their mind to the role played by Samuel Ofosu Ampofu. That's what government is saying in this white paper. And that's why they have brought it in. In fact, when you read this white paper as a lawyer, you come to the conclusion that what government has sought to do is to use this white paper as an appeal over the findings of the Commission of Inquiry and set up the appeal and exonerate the persons, constitute themselves into a judge and a jury, or if you want in the ordinary man's words, a clearing agent. That's what this white paper has sought to do. And that is what is more...
Let's understand something. And law practitioner and teacher Justice Stramsai wrote this. I want to I want to read it to you and then find out if that is your position.
Okay.
And then Penka will also tell us if this is an accurate position.
Okay.
He says, Justice Stramsai, he teaches the law at GIMPA. He says, the president seems to have mistaken the Short Commission for one of his numerous investigative committees that he often sets up in his office. By way of a reminder, a commission of inquiry is a constitutional judicial body whose adverse findings against individuals, when published, apply as a court judgment. This on the face, we all know this. Indeed, the law allows the president to reject the recommendations of a commission of inquiry. In doing so, the president may, through a white paper, give reasons. What the president has done in the Short case, however, is profusely confuse a recommendation with a finding. A finding is a product of a judicial process. It derives from the judicial power that the Constitution confers on the Commission. A recommendation, on the other hand, is what the Commission entreats the President to do with its findings. A recommendation is therefore merely political, not judicial. Being political, the President can reject a recommendation and then give a policy reason for doing so. What the President is not entitled to do, however, is to constitute himself into an appellate judicial body over the Commission, reviewing the merits of its findings or reversing them. There are two reasons for this, and he gives them very shortly. One, the Commission, as I've already said, is a quasi-judicial constitutional body whose adverse findings against individuals are judicial in nature. The President has no authority to exercise judicial power, let alone a final one in this regard. Two, the Constitution expressly reserves such appellate judicial powers for the Court of Appeal, not the President.
Exactly.
He seems to suggest that the President has committed an anathema, a sin that cannot be forgiven.
Forgive at all. It's an egregious violation of the tenets of the Constitution. Look at 281. The Commission of Inquiry shall make a full, faithful, and impartial inquiry into any matter specified in the instrument of appointment. In this particular case, C111. Report in writing the result of the inquiry, and C, furnish in the report the reasons leading to the conclusions stated in the report.
Okay.
So recommendations, yes, there are for recommendations. Government can reject the recommendations, but he cannot reject a finding of fact.
So,
and he cannot reject it because...
Question now is what should be done or what ought to be done. There are groups that are asking he should withdraw the white paper and actually giving deadlines to the president.
To be honest with you, Samson, when I was reading the white paper, I was tempted to believe that this was not a white paper originating from the Attorney General's office until I finished reading the paper and I saw the Attorney General's signature. Because you can't constitute, you can't by the white paper constitute yourself into
what
an...
should be done? Let's move forward. What can be done or what should be done to cure the problem you say you have identified with the white paper?
Well, so the president could, I don't know what can be done now that there's no precedent. You see, if the president, you see, this white paper, again, reading it, I thought the president, if he had these feelings, should have exercised the second option.
Which is?
Not issuing a white paper.
Not issuing a white paper?
Yes.
Okay. Right, so, Panka, briefly, I needed to go to Kweku before you, but because of the legal aspect of it that has come in, what is your position on this? And some have asked the question, what exactly is government fighting in this white paper? What are you fighting? Because it does appear that the Emil Short Commission's focus, concern, and interest was to secure an improvement in our security, our collective security. And they say it in the opening paragraph, page 6.
Page 6.
They say so. But it does appear the government is looking for a certain parochial interest to protect. What is it?
Thank you very much. And let me begin by saying that it is not true that government has a certain parochial interest that it seeks to protect. And I would start again by just looking at Wikipedia, and then we find out what's the meaning of a white paper.
Yeah.
And a white paper is an authoritative report or guide that informs readers concisely about a complex issue and presents the issuing body's philosophy on the matter.
Yeah.
So what the president did was his philosophy on the matter.
Yes, his policy statement.
Sorry, don't intervene. Yeah.
Okay, that was his philosophy on the matter, and it's for you to either agree or disagree. That's all. He's entitled to what he did.
Is he entitled to seek to challenge the findings, which are findings of a high court?
Yes. You see, if for example they found out something as a matter of fact, and in their own conclusions there's a contradiction which the president points out, what does he do? He should leave it? No. You see, there are quite a number of things here. If you read the three that he spoke about, Honorable Hussein spoke about, it says that the president shall, subject to clause 4 of this article, cause to be published the report of the Commission of Inquiry together with the white paper on it within 6 months. The president has done that. He has published it with the white paper.
Yeah.
And it is the white paper that you are critiquing. But the point is that the white paper is a reflection of his philosophy on the matter, which is what I have said. And once it's a reflection of his philosophy on the matter, you can do a critique. But the fundamental thing is whether or not it was within his right to do what he did.
The law lecturer says, do you agree or disagree? Says the recommendations are of a political nature. You can deal with them however you want. But the findings of facts, especially adverse findings, you have no right to tamper with them because of what the Constitution says. That it is only in the Court of Appeal that you can go and deal with them.
Yes, but as you see, the findings of fact, as you have indicated, if also you have some findings of fact by the Commission, which are clearly stated, and on the next leg, an action by the Commission contradicts that finding of fact they made, it should not be allowed to go. You have to comment on it in the white paper. You see?
Where are you supposed to challenge it?
Something, hold on.
If you have a challenge to that, where do you do it? Do you do it with a white paper or in the court?
You see, it is not for government to go to court to challenge that.
Okay.
Hold on. You see, you remember that in reading, I don't want to repeat it, it's now become boring. In reading, he stated clearly that those who are affected have the right to go to court to challenge it. You know, you even know that there's even something that I think we've not looked at it in detail, whether or not the findings of the Commission of Inquiry can be the basis to prosecute a person who appeared before them. Has that not been settled? Yes, but even there, that was one thing I wanted us to come to.
Again, that's a High Court decision.
Yes, why were we recommending that persons who appeared before the commission should be prosecuted?
Yeah, but not on the stated facts, to be prosecuted.
You know, so, hold on. You see, if you appeared before them and you gave evidence, testimony, and then on the basis of which you are recommended for prosecution, Justice Mahfouz's decision will catch you.
That's a High Court decision.
Yes, but you see, what is the law as we speak? Is there any pronouncement on that matter by the Supreme Court?
No.
So the High Court becomes then the authoritative pronouncement on the matter as of now. And you are aware of that. Most of us thought that if people wanted to challenge it, they should have gone higher for us to find out whether what Justice Mahfouz, JSC as he is now, whether his pronouncement at the time could have been reviewed. But as it stands now, that's the law.
They aborted the appeal themselves.
Yes,
no, but that's the law.
That's the law.
Even in that's the law.
Yeah, so if that is the law,
all right,
then even you find that even some of the recommendations.
So see, the point he's making here is that the commission recommended prosecutions. It should not have been recommending prosecution. That's what you are saying.
About those specific persons who
because that's what your white paper says.
Yes.
Okay.
Otherwise, it will die in the face of the in the Republic versus Kwadwo Mpieni.
Okay. Now let's hear from Kweku. The question people are asking is really, what's the government fighting when they make recommendations for the improvement of the security architecture from the top to the bottom, particularly national security establishment? Then, even before they do that, they predicate their findings on, they said, are broadly predicated on the need to put the country's security architecture and future electoral governance on a more stable footing in view of their centrality to the sustainability of Ghana's democracy. They talk about vigilantism and how to fight it. When they talk about the security architecture, the white paper says, oh, they do these things in accordance with law and in the Constitution, so forget it. militia, this is how we are supposed to deal with it. They say we don't agree with use of militia, and even vigilante, what you are recommending has been overtaken by a law the president has. Is that the way to approach it?
You know, I wonder what really the issues are. The principle, does the Constitution enable the executive, in this case the president, who is the recipient of the report, does it enable him to express an opinion on the matter?
Yes.
It does. What have been the precedents too? I've been going through white papers of the previous commissions of inquiries. And I see the same thing. Some findings were rejected, some recommendations were accepted and also rejected. But that's just a sign is educating. And I say so because I like that distinction about you can't reject findings, but you can reject recommendations. But throughout my study, and it's not yet conclusive, I've seen white papers that have rejected some findings. Even the Ghana, the blaster, World Cup
Committee.
Yeah.
They also found that was rejected.
Oh,
I just read it entirely before I came
please,
here. Unless you
please,
can point to one.
go and check it.
I've just read the finding. There's one finding that was
findings
rejected
were made
on the basis of the fact that it was inconsistent with law.
See, but
So you have to provide that this finding cannot be accepted
wait,
by law.
but you have challenged,
Thank
you
you.
have, but you've confirmed the point. No. If it's finding, it's finding. Then leave it.
Thank you. We have very limited time.
So you've just confirmed it. Go and check the Constitutional Review Commission report and the white paper. They rejected some. The idea to make even the National Media Commission rather the source of giving frequency, allocation and things were in there. Government rejected it and said no, it should remain within the domain of the National Communications
That's a recommendation.
Authority. Okay? There are many. I personally, sitting here, have reservations about the government position on the criminal assault against Sam George. I have a serious problem with that. I thought they should have accepted it. They should have allowed that thing to go to court. But I asked myself, even that comment, does it stop it from going to court based on the Mafusai judgment? It doesn't.
Yeah.
So perhaps it's a futile
Exercise. Yeah, I agree.
Also, I'll be honest with you, the point about taking out the SWAT team, a standing force from national security sector, I wanted it done. They should take them out. And I brought here, look, the Constituent Assembly of 1969, 68, 69, those proposals were made. And they were looking at Nkrumah's era and saying that Nkrumah created those some standing forces and things, some of which Colonel had alluded to earlier. And they felt that we should not replicate the thing in the 1969 era, 1979 era. But look at us, in the Fourth Republic, we've brought what we say Nkrumah did wrong.
CSO leaders have been talking to me, and what they are concerned about is that, as far as they are concerned, the recommendations about improving the security architecture of the national security, the chain of command, and the question of vigilantism. Government can reject militia. The question of vigilantism. The manner in which the government went about rejecting those things, they are concerned because they feel that that is our collective security, and it is the reason you set up the commission.
Yeah, but that one, I'm a bit confused there.
Right.
The vigilantism, the act.
Yeah, they said they simply told them that it's been overtaken by the act.
But are you suggesting this is not a cure for the perceived threats that the vigilantes pose? Is there something wrong with this? Do we need to improve on it? The act, I mean. Do we? You were in Parliament. So then that point government is making is plausible.
Okay.
It's plausible.
All right.
Because if this is enough cure for it now, then we shouldn't be making a case.
This is about punishing wrongs when they are committed.
Yes.
Here, they are talking about steps to take.
To do what?
Internally in the structures.
Yeah, so then you are not talking
some of the
so
things.
then you are not talking vigilantism.
Yeah.
It's part of it. The recommendations of
No, but I mean then they got it wrong. Because unless we are telling ourselves now that this is insufficient. And if this is insufficient, then we should be improving on it. That's the point I'm making.
This does not speak about reforming institutions and things. This is only a law to punish if you commit a wrong.
Yeah, so don't bring in the
They
vigilantism.
as a commission's purpose also, we have been told, is for reform. So
Yeah,
why do you reject the reforms?
Yeah, but then don't mix it. Don't mix it with the cure for vigilantism. Don't mix it, because we have this legislation here, unless we think it's insufficient. And if it's so, then let's go and make it stronger.
All right, thank you. We've run out of time, but in a minute, what can you say about...
In actual fact, you shouldn't have made me speak. You should have made Colonel Ryder speak.
I'm like the last one. Now, my fundamental issue with this report, I think, has been captured by the Honorable Minister. If I have used the word, the impression I have is that the government has rubbished.
When you say minister, who are you referring to? The former minister.
Sorry,
okay.
the former minister.
Okay.
He's been promoted.
The white paper
Yeah, so he's got only a minute.
appears like rubbishing the AWW report. And fundamentally because I find it a bit disingenuous that the white paper should start on page 1 in paragraphs 1 and 2 by trying to establish causality with the statement by the party chairman. Now, I've been asking myself, was that one of the terms of reference? Because broadly speaking, maybe yes. But let's remember that the government had authorized, through its structures, a security operation which went either A or B directions.
Okay.
So the government ought to pronounce itself on some aspects of that operation, i.e. that actionable intelligence.
Okay.
Was there any The whole idea of this national security architecture, its command and control, and what I fear most in studies around coup, the syndrome of two armies.
Okay, we have run out of time. I'm very sorry. This is where we draw the curtains, and thank you all very much for keeping your dials on Joy 99.7 FM and our affiliate stations across the country and also on television. And one senior lawyer says that I should tell all of you that coup is a crime, and that a successful coup is not a crime. Once the coup is successful, it is not a crime. All right, my guests have been Abdul Malik Kwekubaku, editor-in-chief of the New Crusading Guide newspaper, Colonel, retired Festus Abuaje, author and conflict analyst. Joseph Dindiok Penka is MP Timpani and Deputy Attorney General. Inusa Fuseni is MP Tamale Central. My outfit, as always, is by Latida. And the point is that no successful coup is a crime.
But
thank
why
you.
they put it.
MTN.
Everywhere you go.
Star Assurance, your solid partner. Bank of Africa, as strong as a group, as close as a partner.
Amen Scientific, Herbal, and Alternative Medical Hospital. Allahu Shafi, God is the healer.